Hi, guys. Go ahead and get settled in. Hope everyone is doing well today or tonight, depending on which part of the world you are from. So go ahead and get settled in. I'll let everyone have some chance to come in. You must be on the East Coast. It's past midnight here. Yes, that means you're in the East Coast. It's 11:30 something ish on my end. So, yeah, late night. I had a packed day today and I have a packed day tomorrow. Um, and I wasn't sure what Thursday would look like, so I decided let's squeeze this in. Let's squeeze this in. Um, you are exactly the opposite time frame as your daytime. It's afternoon for you. How interesting. Noon in the Philippines. Hello from work. Go ahead and get settled in as you do. I'm going to go ahead and pull up my questions. I've got my other computer on this side, so I might be at times turning around this way. If I am, that is because I am going to the questions that have been collected um, for the purposes of answering. Thank you for taking the time to do this. You're very welcome. All right, we're going to again just give everyone a few more minutes to come in. I'm going to pull up the questions while I'm doing that. And then we're going to hopefully kind of stay on track with our topic matter so that I can get done, get some sleep in tonight, and get to work tomorrow. So we're going to attempt to do all of that today in a very short time frame. So as I give everyone else a chance to come in, if they hear that we're on, let's go ahead and start with a couple of announcements. Those of you who have followed VLM for a very long time are already aware of this, but in case we have newcomers who come by and watch the live. So very first thing, if you look at VLM on Instagram or on Twitter, you will notice both the channels have information about who we are, what we do, and what that means. VLM also includes information about legal disclaimers and legal pages because we try to maintain as much professionality as we can in this organization. I had recently had questions about our legal team. If you again, actually, if you look at one of our rather recent posts, you'll find one that actually thanked my legal team and thanked my admin team. You'll be able to see exactly how many legal members there are and how many admins who are non-legal members we have on the team. After the last live, I had someone who came up to me and was all like, who pays this group of people to do this? Well, in case you're not reading all of the documents that were posted right when VLM started, let me reiterate, VLM is a voluntary organization run by people who volunteer their time. We are not your lawyers. Several of us belong to different legal professions, all the way from North America to South America to Europe and Asia. We cover several continents. We have various different experiences and backgrounds, and we volunteer our time and our resources. We have educators in VLM who serve as my admin. We have individuals who have multiple degrees in VLM. Our chief administrator is both a nurse and has a legal degree. She's a legal nurse. So if you look at our pages and our sites, you'll actually get to know that we have a very robust group of individuals who give their time, and our time is given for one reason and one reason alone. We want to share the knowledge we have. And any information that we give is going to be based on facts. It's going to be based on the letter of the law. It's going to be based on legal analysis and legal insights. We will not talk about gossip. We will not talk about assumptions. We're not going to make predictions that are not possible to make because we don't have superpowers. So we will stick to what is known and what can be understood or interpreted from the process, from the laws. That was my spiel for the beginning, so that from here on out, anyone who new comes around, you don't have any questions regarding us. And if you do, go to VLM Twitter, VLM IG, look up our legal pages. We have all of that there for anyone to see so that there are no questions, concerns about who we are, what we do, and what that means. So thank you very much. And on that, I'm going to actually going to get started with my first question. The first question is a question about what do we do if we think the judge is wrong? What do you do? And in this case, the question is related to Sungri's case, SR's case. However, we're going to talk about this in general first, just to take a step back. It always helps to take a quick step back. So our legal system has been built on the premise that there will be due process and there will be fairness. But our legal system is also built on the premise that we are people, we are human, and human beings, no matter how experienced we are in our fields, how good we are in our fields, or how unbiased we think we are, we can still make mistakes. So, what do you do when you believe that a court has made a wrong decision? They have made a mistake. Who do you go to? It's built in a system that allows you to remedy something in that case. And that system is called the appeal system. So when you think that court has made a mistake, that is what you do. You appeal. So when you think the court has made a mistake, you're not wondering, oh my God, where is my system? Your system is already built in. And this system is built in South Korea, and this system is built in the United States, and it's built in Japan, one of the other locations that I've practiced in. So it's built in several different jurisdictions because those of us who practice law know it is possible to make mistakes. So that was the very first answer. Appeals exist because we understand that mistakes can be made. All right, let's move on to the next question. I see people are talking about non-legal related things, but I will take a quick short moment to respond to them. First, you're very welcome for my time. Second, yes, Mr. R has taken over my Instagram. He does that once a year. August is my birthday year, birthday month. So he does that once a year, and it's taking place right now. He has my phone. He literally has my phone. And I'm here with you guys instead. So let's move on to the next question I have. Most of them are very similar to each other. There is just a lot of overall question about this appeal process. The first one that I will answer, or rather the second one I'm answering now, is directly related to who can appeal. There was some confusion because I think there might have been one or two Twitter posts about the fact that only defense can and not prosecution. So, first thing we want to make sure is that when you go away with facts. Every legal jurisdiction is just a little bit different than another. On top of the fact that jurisdictions, even inside a big country like the United States, differ. So, practicing law in Washington, D.C. is different than practicing law in California. Practicing law in California is different than practicing law in Texas. Similarly, practicing law in a whole different country's jurisdiction is very, very different. In the United States, it's absolutely 100% true that only the defense can appeal. The prosecution does not have the power to appeal in the United States of America. This is true in all jurisdictions. This is not true in South Korea. In South Korea, the appeals process is one that allows both the prosecution and the defense to appeal. Their premise is this: if a court can make a mistake, that mistake might be in favor of the defense, or that mistake might be in favor of the prosecution. So, in their legal reasoning, they allow both the prosecution and the defense to appeal, to say, hey, I think the court is wrong. That's why South Korea's legal reasoning allows both prosecution and defense to appeal. What does that mean? It means something very simple. If a verdict comes out and that verdict is something that, let's say, completely favors the prosecution, then the defense can appeal it. If it's already completely in the favor of the prosecution, they may not decide to appeal. However, if a verdict comes out and it's a mixed verdict, one that favors them, but maybe not entirely, partly also favors the defense, when it's partial, when it's mix and match, then what you sometimes see is both the prosecution and the defense appealing. That's where it gets complicated in South Korea. If both the side goes, whoa, this is a mixed defense or a mixed result, it sides with the defense on this and it sides with the prosecution on that, neither of us think this is correct. So both sides can appeal. We're going back with that number one part. I see that there's questions coming up here too, so give me a second. I'm going to try to frame the questions so that similar questions are grouped together and we can save on time. So hold on this end for me while I scroll on this end for a quick second. Okay, I'm actually going to answer these first. Were you surprised by the verdict? Yes, I was. Those of you who have read a Business Mirror article might have read the fact that in my analysis, it appeared, and I am using the word it appeared, that all of the witness testimonies that had been taking place during trial. So Sungri had one trial. I also want to correct any misuse of words. Sungri had one trial. People keep on saying trial 4, trial 5, trial 25. No, he had one trial. His one trial had several sessions. Each session is one day at court, which can be called a hearing. So throughout Singer's trial, throughout all of those many hearings, it appeared that witness testimonies were favoring him. It appeared that witnesses were saying he didn't do it, this other person did. They were appearing to also say, what I wanted to say was not this, I was under pressure. And that's what it really appeared. So, as we went through the information that was made available publicly, it appeared that the burden of proof was really weak and lacking. We also didn't really see any direct evidence. For instance, no eyewitnesses who've seen him say, hey, I'm going to do A, B, C, and D. So there had been what, in my opinion, was uh, a rather weaker prosecution case. However, what we've been talking about for the last several months in a row was that even though that's what it appears to be on the surface, there is a lot that has happened in the court that I don't know, that you don't, because they have not been made public. So, what could be there in the court documents? And I've mentioned this in the article as well. Could there have been something in that documents, in the court documents during the actual proceedings, that was substantial, but was failed to be noted and was failed to be reported? Is that a possibility? Of course, that could be a possibility, but it's a possibility that you and I would not know. We would only be left to speculate. Um, but yes, I was definitely surprised by the verdict. I was most particularly surprised because it appeared that as the court sat down to give as their legal reasoning, a lot of those reasonings focused on the moral aspects and less on the specifics of the elements that had to be proved beyond a reasonable doubt. So for each indictment, a crime has certain elements of the crime that have to be proved by the prosecution beyond a reasonable doubt. So if you go through those elements and you go, element one, it's kind of weak, element two is kind of weak, element three, okay, maybe check. If you start going through those elements, you will find that not necessarily have all of these elements been checked off. And what I would have liked to have seen as a practicing lawyer, what I would have liked to have seen was information as to why the judge feel that these elements had been checked. If he was checking them, why are you checking them? What is your basis for checking out these particular elements? But he did not provide us with that information. Instead, he focused more on the moral reasoning. So, again, I won't spend all of my time talking to you about the article. I will instead send you to Business Mirror's article regarding SR's verdict. It's called Verdict, Business Mirror. It's the links available on VLM Twitter. You could still find them there. Okay, so there was another question over here, which I'm also going to answer before I move on to the more substantial questions. So keep in mind, I'm juggling questions to keep them together and to keep similar items in the same area so we can try to be as efficient as humanly possible. Um, is it true SR needs a certificate for appeals? And then a couple of sentences below, someone said that 7 days count to appeal will start when Sungri receives the paper from the court. So how long do you think it will be before he receives it? So one of the first things that we all need to know is this is correct. This is correct in South Korea, and this is correct in the United States of America. What happens is that whenever there is a case, any case, whether it is criminal or whether it is civil, any kind of case, those cases have to be recorded. And in particularly for criminal cases, um, that case has to be filed. Paperwork has to be done. There are tons and tons of paperwork that attorney offices do, which is why they usually have legal secretaries and paralegal assistants and the ton of different legal professions that exist to finish this paperwork is mind numbing. But yes, every single court, at least that I have ever practiced in, whether US or in South Korea, has procedures. That means when you walk out of that courtroom, how would anyone else ever know what took place in that courtroom until and unless the paperwork is properly filed? So, what this literally means is once the case is done, it gets filed. When it gets filed, that's when your clock starts running. The filing process doesn't take very long usually. So his 7 days is not something that, what would I say, that the Twitter world is making it out to be. I would also point out the fact that um, the Twitter timeline, there are discussions about it. I've seen there's gossip there. There is a speculation there. There is some fear mongering there. There's just a lot of things happening in that social media world, and it's understandable when people are curious and people have the ability to Google search, and sometimes they don't always know what they have Google searched and found. It's good to do your own research, but it's also important to understand what that information is saying. So when you find material online, take a step back and ask yourself, what could this material be saying? Is this material telling me that he might never be able to file an appeal if he doesn't have a certified paperwork? That's not what it's telling you. That certified paperwork is a due process. It happens every single time, whether it's a small fry, whether it's someone who's, you know, stolen a car, or someone who's speeded and has a speeding ticket, or if it's someone who's a murderer. It always gets filed. So 7 days appeal. I will talk to you in detail about the appeal. So hold on to all the other appeal related questions while I try to go back through this set of questions and see which ones are coming up in the same region and are going to be similar in, what would I say, in spirit, similar in spirit questions, so that I could try to answer those. And if those questions get answered by my lecture on what is an appeal, how does it happen, then those get answered as I start explaining the process. So hold off on the hard labor. It's not quite time to discuss the hard labor yet. Let's go back, take a step back, and let's start with an appeal. Okay, so just a moment ago, I kind of gave you an idea of what the appeal process was. So we're going to do this classroom style because I'm an educator and I love to do that. So, who would like to tell me in your own words what is the appeal process? So I'm going to let you guys do this. You learn the best when you do a Socratic method. For those who are wondering, what is she talking about? The Socratic method is obviously the method used by Socrates, one of the greatest philosophers. And I love using his method. If you are ever in grad school level education, you'll find that a lot of professors use it because you learn because you get asked questions and you answer. So asking and responding and discussing, that jogs your brains. It fires up your neurons and your little gray matters. In case what you're thinking, what is gray matters? It's the little cells in your brain. It all sparks to life. So someone here must be able to tell me what is an appeal. I'm going to give it one more minute because there might be a time lag. Okay, so an appeal is basically when you are contesting or protesting the results of a court. Here we go. Here it's coming up. Oh, Saba, I wish I could have had you as an instructor while I was still in college. You can come back. I have a lot of students who are of different age groups. 2 semesters ago? No, it's now been actually 2 years. Oh my goodness, time flies. About 2 years ago, I had the most precious students in class. I had a grandson and a grandmother in the same exact classroom. It was precious. So come back to school. Come see me. We'll have fun. Okay, so appealing to me is to object to a ruling or a theory. Very good. Here's the one below. Apply for an appeal and it can be accepted or denied. If accepted, then you get a new trial. The results could be in your favor or not. Excellent. So both of you are on point with what an appeal is. So an appeal is an objection. It is saying, I object. I believe that the court's ruling was incorrect. There was a mistake that was being made. Now, the first thing we need to know, the word appeal and appeals refers to more than just the first step, which is objecting. 7 days that everyone has seen on paper and that is circulating, including the one that Vila mentioned, is the very first step of the appeal, which is to actually formally send paperwork in that says, I object, this is wrong. That's the first step. So that's where we're at. We're at the very, very first step, beginning process. So, how do you win an appeal? How do you win an appeal? Let's begin right over there. What do you do when you have a case and you want to win that appeal? The most important step in starting out with an appeal is to review the current case, the one that just concluded. It is where you start. You start reviewing that case. You review it top to bottom, meaning you review it all the way from pre-trial to verdict and sentencing. You review the entire thing. You look at transcripts. You're going to look at copies of the particular hearings. You're going to do an in-depth review. You're going to annotate. Annotate means taking notes on the sides. You're going to go through all of it. And it is possibly the most important step to begin with. Why is it important? Because you're picking out the potential errors that happened during this case. What were the potential errors? Was there any mistakes that were made by the investigators? Was there any mistakes made during the admission of evidence? Was there any improper statements made by the prosecution that should not have been allowed? Was there legal errors? Was there something that was perhaps an error on the judge's part? Was there certain factual errors? All of this. So that's the very, very first step. That's first step. Second step is to talk to your client, whoever they may be, in this case SR, and decide, what does SR want? Given the fact that we have several guilty verdicts, SR has two options. SR can decide to appeal the verdicts themselves. He can appeal all the guilty verdicts, one by one by one by one. He could also appeal only a few of the guilty verdicts. He might choose to appeal prostitution and prostitution mediation. He might choose to appeal embezzlement. He might choose to appeal illegal monetary exchange. He might choose to appeal a few here and there. Now, The ones that I'm mentioning, randomly mentioning. I don't necessarily mean he will choose these. These are just examples of how he may choose certain ones and not the others. So he can choose to appeal all the verdicts, or he may choose to appeal some of the verdicts. There is also a second option. In the second option, he doesn't appeal the verdicts themselves. That means this: if a person does not appeal a verdict itself, it means they're saying, okay, I accept the verdict given by the court. In this case, those would be guilty verdicts. However, I feel that the sentencing is wrong. It's incorrect. There's an error. There's a mistake. I will appeal the sentencing instead. So, in case someone doesn't choose to appeal the verdict, they can then choose to appeal the sentencing. All right, so I'm going to take a break and I'm going to look at all of these chitty chatties going on this side. And I see, thank you guys. I see the birthday messages. Thank you very, very much. So here's another question, and I'm actually going to answer it over here because it's also a question that I have received prior. Is it possible that SR's lawyer wasn't present because he was getting a new one for the appeal? So there's a couple of potentials there. I'm going to discuss some of them. I wouldn't say all of them because there is no way for me or anybody else to know all of the potential that existed there. So we're going to begin with that disclaimer. At this point, what we're doing is called hypothesizing. How is it different from taking wild guesses? Well, wild guesses are pulled out of thin air. Hypotheses are based upon evidence that we've collected, prior knowledge to draw certain potential conclusions. So, hypotheses. Um, hypothesis. Why would SR's lawyer not be present? One, it could be because he's potentially or was potentially preparing for getting ready for the appeal process. Two, uh, SR's lawyer could, again, knowing that an appeal might be necessary, might be looking into potentially working with other individual lawyers. What do I mean by other individual lawyers? Um, Lawyers have specialties. I'm a human rights lawyer. I work particularly with women and children. Uh, a lot of refugees, a lot of individuals who require that special attention. So, similarly, there are people who are, let's say, experts or their specialties are business. Mr. R, for instance, there are people whose expertise lie in medicine, such as our chief admin F. She is a legal nurse with expertise in medicine and law. So everyone has specialties. There are lawyers who specialize with appeals. There are particular lawyers whose entire careers are built with expertise towards appeals. So, one SRS lawyer could have been preemptively planning for the appeal with their own team. Two, SR's lawyer could be consulting with a potential second party lawyer who they might decide to work with or not work with, who specializes in appeals. Um, so these are two of the potential possibilities that I'm looking at right now. Now, because I brought up that potential of working with a new lawyer who has a specialty in appeals, if that happens, then this new lawyer who has a specialty with appeals can be the person who presents the appeal case to the court, who's going to be judging if this appeal should be accepted or not. So if they do decide to go with a specialist, then that specialist would be the person doing the talking. That does not necessarily mean the whole team is gone. It just means the whole team now has a teammate. They're tag teaming it. However, and I throw in the however, because in the legal world, you can also say goodbye to the old lawyer and start out with a new. And again, these are not information that anyone should panic over. These are simple facts of what can happen based on what procedure allows and what usually lawyers do. So that's where we're gonna end right over here. I have more questions, so many, so hold on to your horses, everyone. Let's move here first, since I've been reading out of here for a moment, and then I'm going to come back to this one. Okay, so we're going to read one of them. It's in the same area that we're at. So give me a second. If the appeal is denied, will they give a reason? And if that happened, then what is he out of options? So if an appeal is denied for a verdict, okay? So let's say SR has filed an appeal, or any individual has filed an appeal against one verdict or several verdicts. If that appeal is denied, is that the end of it? The answer to that is no. There's other options. You can appeal the appeal. Yes, there is such a thing as appealing the appeal. But more commonly, you can also set aside the verdict and appeal the sentence. So, okay, fine. You don't think that there was a mistake, and by you, I'm talking about the court of second instance that is judging if there should be an appeal accepted. You don't think that there was a mistake made in the ruling of the verdict. Okay. Let's instead talk about the sentencing. The sentencing is too harsh. The sentencing is incorrect. There's a mistake in the sentencing because of reasons A, B, C, and D. If you cannot get the appeals done the first time, you can appeal the appeals and you can move on to appealing the sentences. So there are still options in place. The other question that I'm going to answer, because again, it's right there, and again, I'm trying to group similar questions together, is about where he is and what's happening right now. So during this 7-day period process, he's held in custody. It's not called being held in prison because he's not in prison. He's held in custody. The custody period is one during which he's allowed to make his decisions. Do I appeal? Do I not appeal? South Korea does have the option of bail. Bail in South Korea, once you have been convicted, and I'm going to repeat myself, once you have been convicted of a particular crime, bail is not a constitutional right. That means you don't automatically get it. It's not guaranteed. But bail is a potential and a possibility that a lawyer can fight for in court and get. Meaning, SR does not have to remain in custody prolonged periods of time. After the 7 days, after the first 7 days period has passed, his lawyer, his team, can then start working on a bail process. in the sense that it's sometimes easier to compare laws. Texas is very similar in the sense that Texas Constitution, the United States Constitution, does not guarantee bail to someone who has been convicted of a crime. However, you could still, as a defense attorney, pursue a bail. If it's not a guaranteed right, it is one that you show reason for. And if you are the one asking for a bail, the burden of proof is then on you. So when there will be a bail hearing, it is the defense attorney's job to show what are the legal reasons for bail. We'll discuss all of that in detail later on, but I think this should give you guys a general idea. All right, let me see if there's anything else here, and then I will move back to there. I'm going to answer this one in particular. It's not a legal question, but I'm going to answer it because it is related. What if we shared his situation in all platforms? Would that help him? Or if the Korean VIP make a petition to the Blue House adding the name of the real people that committed the crime, they succeeded in their situations, why would they not succeed in this one? Especially that everyone all over the world is reading this and puts SK in a very bad situation regarding the law system. Okay, so does something such as a petition or a Blue House petition have a way to aid this particular situation? Probably not at this particular time. At this particular time, it all hinges on the appeal. Um, Remember at the very beginning of today's live, we discussed what the appeal exists for. When you believe that the court is wrong, there has been a mistake made, there has been an error, there has been something inconsistent, things have not been the way you thought it would be because you believe the evidence did not support the verdict. When you believe the court is wrong, your way to complain is the appeal. The appeal is your complaint. The appeal equals complaint. So right now you want to know about what should the process be. The process should be letting the individual who is the person who's faced the charges and has been convicted decide, do they believe this is unfair and wrong? Do they want to challenge this or do they not? So at this point, I think that what most people should do is wait for the individual to make their choice. And this would be true even if it wasn't SR. Any individual who is facing any kind of criminal or even civil circumstances, it's their life decisions, right? They're human beings and they get to choose whether we accept it or not. And that's something we do even with our family. Families sometimes make decisions we completely disagree with, but we have to let them do what they do because it is their lives and their right. So I would say wait for him to make a decision. Is there something that a community can do? Yes, spread facts. The biggest thing that a community can do, that they have the right to do, that doesn't overstep and become a little too, how would I say this, interferes the way sometimes fan culture tends to be, would be to let the individuals make their decisions while you support them. You support them by sharing real facts, by finding other sources that are citing facts instead of fiction, upvoting those particular ones, by clearing search engines, uh, by reducing digital footprint of fake news and misinformation. You reduce those digital footprints by number one, disengage trolls. Trolls has never helped anybody in any criminal circumstances. Fighting with them does not help. So disengage, lower the footprint, increase positive footprints instead. Um, so those are ways that you can currently help. I'm going to continue reading here one more second before I switch gears back to my computer screen over here. Okay, so a lot of the other ones are about the procedures, the when, what, where, when, how, why. I'm trying to make sure if there's anything not necessarily related to procedure. There was another part of the question. If an appeal is denied, will there be a reason? Yes, if there's an appeal that's denied, there will be a reason. And I already mentioned the fact that there will be options. Um, Here's another part to it. All right, and I think I saw something related to appeals here. But before that, I see another question. Hi, Saba. Will we ever see the judge's findings regarding his decision on each charge and the sentence for each charge? Unless they are approved to be shared through the court, then my answer is going to be no. That is actually what I was waiting to see. I don't know if you came in early enough for when I was saying that I was surprised by the verdict, because I was literally looking for um, prostitution mediation found guilty or not guilty, because I was literally looking for that where we went through from uh, number one indictment all the way down to number nine indictment. I was literally looking for the legal elements of the crimes that the court believed were met, but they did not exist. Now, just because it doesn't exist for us doesn't necessarily mean it did not exist in the courtroom. So I also want to make sure I say that one more time. Okay, I think that I already answered the fact that uh, when SR reappeals, will he stay after his military discharge in the detention center or prison or at home? Okay, so that's a great question. We're going to get to that. And while we get to that, I'm going to take a quick water break. So give me a moment. We're going to start right there with how the appeal is going to start. So we're going to go through process, guys. But but will that mean that the lawyer already knew the result of the credit and that should not be possible or legal right? So, Pam, you are referring to in case the lawyer was preemptively not there because they were preparing for a verdict. Does that mean he already knew? Um, there's a couple of ways of looking at that. The first way of looking at that is that uh, after the last hearing, he probably felt nervous, and after he turned in his written uh, documents for the modified indictment, he could have felt nervous. Remember when every I think it was the last live, and also we mentioned it during some of our the VLM postings, that any good lawyer worth their salt has played out every single scenario, including the worst case scenario. And usually, if you're in court, if you go to trial, if you are a trial lawyer, whether it is as a human rights lawyer, as a defense lawyer, as an appeals lawyer, if you are a trial lawyer and you've been in court, you get a feel of where your case is heading by the time this case is coming to an end. You get a very, very, very good feel of, I'm in trouble, or woo, this is going to be tight. It could go either way, or oh, don't have a chance. You get a fairly good feel of how you did, how the prosecution did, how does the jury feel. I practice in the US too. How does the jury feel? How does the judge feel? You get a fairly good sense of being able to get this idea. So it's not that he had a paper sent to him that said SR is going to be found guilty. If he had preemptively planned for it, it's because he has been planning out different scenarios from the beginning, like a chess game. He has played out how many guilties and not guilties there could be. Could there be one guilty and all not guilty? Could there be two guilties and all, the rest not guilty? What happens if there's five guilties and the rest not guilty? What happens if there's all guilties? He has been playing this out like a chess game in his mind, and he should have been playing that as a chess game in his mind even before the final hearing. So by the time he's come to the final hearing and he's already played out all those chess moves, he should be able to tell pretty well what his chances are. You don't know, I don't know, but he should have a fairly good idea of what kind of trouble he's in or what kind of trouble he's not in. So it's not a matter of someone having slipped him a note that says it's going to be guilty, or it's a matter of experience as a trial lawyer. All right, so we're going to go back. As I said, there's a lot of questions, but a lot of these questions will get answered if I start with the procedure and start moving. So if you guys would just hold on to all the other questions. For instance, so it would be really, really good to hold on to those extra questions because I think many of them will get answered if I am allowed to just begin with procedure. Okay, so first step, as we said, was reviewing the case. Second step, after deciding their course of action, meaning are we appealing all of the verdicts, some of the verdicts, or we're only going to appeal the sentencing. After deciding on the course of action, the next thing is to develop an argument based on law. All right, so now we know what we're going to do. We're going to, for the sake of argument, assume that we're appealing two verdicts just to keep it simple number wise for us. So I'm going to carefully think about the arguments that I can use based on law for why these two particular verdicts are incorrect, why it's a mistake, why it's an error. These arguments can have a basis in the law, as in things that are existing in the criminal code. It can be based on court procedure. It can be based on the Constitution. It can also be based on facts of the case. So, my arguments that I'm now going to develop can be based on law, can be based on court procedure, can be based on the Constitution. All right, we've made one more step in our journey. After that, what do I need to do next? Next, that I've developed my argument for each of these that I want to appeal. My job is to establish a full or partial innocence. If I'm establishing full innocence, that means I am appealing each one of the indictments that were found guilty. If I'm establishing my partial innocence, then I am only picking and choosing a few out of the whole. Maybe I'm choosing four. Maybe I'm choosing five. Maybe I'm choosing three. So I'll be establishing my full or partial innocence. And to do that, I cannot I cannot only focus on something that is legal or factual. It cannot just be legal and factual. There has to be a balance of these legal elements, and this is where having practice in court matters, an emotional element. So one of the things that's going to be important is your ethos, your pathos, and your logos. I just use big words there. Your authority or your credibility, your logic, legal logic in this case, and evidence, and the emotion to stir the court. If this was a case in America, it would be the emotion to reach the jury. In South Korea, it is the emotion to reach the judge. The best trial lawyers, the best appeal lawyers are absolutely experienced, not just in the other part, in, the arguments that they've developed, but they're also very good in that emotional part. And sometimes, if you're a human rights lawyer, sometimes you are actually defending individuals who are innocent. And when that happens, the argument isn't just technical. The argument isn't just about that technical mistake made in court, misjudgment of law, misinterpretation, or misapplication. It's a lot more than that. It is about the failing of a legal system, and when that happens, the harm it does to an innocent. That's what human rights law is all about. It's about the fact that when the legal system fails, it greatly harms an innocent individual. And when it harms one innocent individual, it harms the entire society. So the best lawyers are ready to try to establish full or partial innocence. What happens after that? After that is the part that everyone really is wondering. That's where you start working on releasing your person, your client, from custody. So, because the rest of the process is long and winding, you want to start working on how can I release the individual who's held in custody. And to do that, as I mentioned before, because once someone has been found guilty, they no longer have a constitutional right for bail. Not in the United States, not in Texas, not in South Korea. Once you're guilty, that constitutional right doesn't exist. However, you do have a right to file an appeal, just not, to bail. Sorry. Freudian slip there. You have a right to apply for bail, despite it not being guaranteed. What's the difference between right to do it and not guaranteed? Um, Guaranteed is when you have been guaranteed you're going to get an A in class. I've been guaranteed I'm going to get an A in class. There's just no way I can get anything less than an A. The right to get an A means, on the other hand, that you can try your best. You can turn in the best work you have. And if you are hardworking and you've followed all the steps and your professor grades you and feels that you deserve an A, you can get an A. So the difference between a guarantee is one that says you're going to get it, and not a guarantee, but a right to do it, is that you can do it, but there is absolutely no guarantee you will or will not succeed. So there is a right to apply for bail. No guarantees that it will be granted once you have been convicted of a crime, because you are at the point of conviction. You have lost the presumption of innocence. At the point of conviction, you are no longer presumed to be innocent. That's one of the reasons why the guarantee is no longer there, but you have the right to pursue it. Again, great lawyer is necessary because the burden of proof is on the defense. They must prove why a bail should be granted to their client. Why does SR deserve a bail? Why does he deserve it? And that's why it's so important that sometimes people decide to get extra help during the appeal process and find a specialist in appeal. As I mentioned before, again, sometimes you have lawyers who specialize in appeals. Okay, so we're going to continue just a little bit more. Um, talk a little bit about some of the things that the court is going to review. So I know there's going to be like a ton of questions. So let's say the appeal process is on the way and you've started it and you're now starting the process for bail. What in the world is the court going to look at? What in the world is the defense and or both the appeal lawyer, in case there's two lawyers working together, or one? What are they going to submit? What is it that's going to get reviewed to see if a bail is appropriate for this particular individual in this particular case? Uh, some of the factors will include, and if you want to take notes on this, you can, because this is important. The seriousness of the crime. In this case, there are 9 indictments. The seriousness of each of the 9 indictments. The length of the sentence. The total length. Criminal history. Do you have priors? Do you have a clean slate? Your ties to the community. Are you a community member? Are you a preacher? Are you someone who owns a business? Do you have parents there? Do you have a sibling there? Do you have close friends and relatives? What are your ties to the community? Your ability and your likelihood to be able to travel and escape, meaning you becoming a fugitive. What is your ability and your likelihood to be able to travel and escape becoming a fugitive? Ability is one, meaning you have maybe financial capability or other assistance. Likelihood is something different. Likelihood means even if this person has all the money in the world, are they going to make a run for it or are they not? And finally, the court will consider the factors that are: what is this individual, if released, what is the risk to public safety? So, for the bail, these are the various key factors that the court will review. And it will be the job of the lawyer to show that these factors indicate that bail is appropriate for SR. All right, I am now going to stop for a moment. This is going a little crazy, which of course I knew this would go a little crazy. So let me keep reading. Um, I'm going to uh, skip some of the conversation, especially if I feel that they're kind of going in circles. But I'm going to point this one out. If he appeals and deny the appeal, can the petition on humanitarian organizations or whatever help after? So if the appeal is rejected, the second step is to appeal the appeal. or to appeal the sentence. So if an appeal for a guilty verdict is rejected, meaning they don't think that guilty verdict is wrong and there is no ground for it, then the next step is for SR and SR's lawyer to either appeal the appeal or to appeal the sentence. So there is no reason to go to a humanitarian organization at that point because there are still legal steps left. So you have all of these steps left in the legal system. So you're not going to skip all of these steps and go running to an organization who's probably not going to do anything for you because they're going to say, there's an entire process left for you to go through. Have you done it? And you're going to say, no, I didn't do any of it. So this is not the time to go anywhere, any place. This is the time to let them go through the process, all the way to the Supreme Court if necessary, which is why the law takes time. It can, and I'm not talking about SR's case, because if I mention SR's case, people are going to panic again. I'm going to use just a random example. Some cases take 3-4 years. Some cases take 5-6 years. There are some cases that take even more because law takes time. If you go through the entire justice system, from the first court to the highest court of a nation, many jurisdictions have 3 levels, like United States, like South Korea. You're talking about going through 3 levels of the system. It can take many years. So until you've exhausted every step along the way, there is no outside intervention because you have been built in a system of complaint. You've been built in a system that says, I believe this is wrong. Okay, let's take it to this level. They get to judge if I am correct that this should be reheard or not. They still don't agree. Okay, take it there and take it there. You go up the system all the way to the Supreme Court. That is your legal process. That is due process. And it's the same in most jurisdictions. You go from the bottom to the top. And humanitarian organizations usually are not going to be able to do much for you in the legal sense. If you are in the United States of America, you could go to the Innocence Project, for instance. But again, the Innocence Project wouldn't be something that you would go to until and unless someone has been convicted and sentenced to prison and is already serving prison. And their lawyers have given up. So even then in the United States, even if this case were active right now in the United States, it's not the time for Innocence Project to get involved because there hasn't even been an appeal yet. He hasn't even gone through the appeal process. His lawyers haven't finished yet. So the Innocence Project, even in the United States of America, would not get involved in this point in time because they have not gone through the entire system yet. You have to go all the way through the end. There has to be an ending to understand that, okay, the ball was dropped. The ball has not been dropped. The ball is still in the game. So I think that's something that what we need to understand. A lot of people are assuming that the game is over. The game is not over. The ball is in the court and the ball is still moving in the court until the ball is ended, dropped, finito, the end. You don't have outside intervention coming in because the ball is in play. The ball is literally in motion, in the air, moving from one side of the volleyball court to the other, or one side of a tennis court to the other, whatever ball game you like to play. So not the time yet. Everything has its due course and its due time. And again, law is a long process. Sometimes it turns out to be fair, and sometimes it turns out to be unfair. Again, which is why you have civil rights lawyers and why you have human rights lawyers, because sometimes there are unfairness in this world. It's just unfortunate, but it is the way it is, and that's why I exist. Okay, so let's go back to 3 levels of court. Eh, okay. In the United States, you have a court of first instance, court of second instance, court of third instance, the highest being the Supreme Court. In South Korea, you have the court of first instance, second instance, third instance, the highest being the Supreme Court of South Korea. The highest court in South Korea is the Supreme Court of South Korea. In South Korea, all civil cases start at the district court. The appellate jurisdiction belongs to the high court. Appellate jurisdiction means where appeals take place, very similar to the US. And then if the high court level requires a second appellate, a second level of appeals, it goes to the Supreme Court. So the court of first instance is heard at the court of second instance. The court of second instance is heard at the court of third final instance at the Supreme Court. That's civil. Military court is extremely similar in structure. In military court, you have 2 levels. Because in South Korea, the Supreme Court is the highest court in the land, it rules over both civil and military. So the number 3 court of instance is the highest. First and second instance from civil court goes there. First and second instance from military goes there. So Seungri's case was handled in military court only because he was active duty at that point in time. Because SR will be finishing out and discharged, he will no longer have his case in the military court. His case will get transferred back to civil court. Civilian court, where you are going to handle with his criminal charges. I do want to make sure that we keep in mind, in case sometimes Freudian slips happen from my tongue, so excuse the Freudian slips. So civilian court basically means non-military personnel. So he'll be a non-military personnel. So it'll take place in the court of second instance. First instance has already been done. That's the first time the case has been heard. It was in the general court. The second time the case gets examined, if it gets approved for examination and appeal, it will be at the high court level, and it will be at the civilian high court level because he will no longer be a military personnel. If there is another level of appeal at the high court, let's say for whatever argument's sake, that maybe this time the prosecution decides to appeal, or maybe the prosecution and the defense, because remember, for a mixed verdict, both sides can decide to appeal. If there is another level of appeal at the high court, then it gets heard at the court of third instance, the higher level, and the third and the final level is the Supreme Court. So again, 3 levels: first instance, second instance, third instance. General, high, supreme. And in case of civilian, you have district, high, and supreme. And the one Supreme Court handles both. All right, let's move on. I'm not going to focus anymore on the lawyer part. I did qualify my answer being that all you can do at this point is hypothesize, and I hypothesize the only 2 legal hypotheses that can be derived from it. Any of the other hypotheses that someone can come up with would actually not be a hypothesis, would probably just be guesswork. So I'm not going to focus on the guesswork part. I have mentioned the legal potential hypothesis that could be applied. The guesswork, you guys can do that on your own on Twitter. I would think that famous and recognizable people would have less likelihood of escaping. That's a very good point. Yeah, everyone knows his face. It's hard to disguise yourself and run away. The ball is still rolling, exactly. So one of the biggest things that the misconception that I see from everybody, whether you believe in SR or don't believe in SR or have no clue about what SR's case is about, the biggest miscomprehension is that the ball has dropped, the case has ended, it is closed deal. It is not. The ball is rolling, the ball is in the game. The game has not ended. This game is far from ending. If there is an appeal, the game continues. If the appeals pass, can he ask for a speed trial, or does that not apply to appeals? So, the right to a speedy trial means this in the legal system. The right to a speedy trial means you don't throw a prisoner inside a prison, lock them up, throw the keys away, and forget about them for a couple of years. The right to a speedy trial means that due process is followed. You create dockets, you try to get them into court at a reasonable pace based on your court's case level and the number of individuals before you. So, speedy trial can still be a lengthy trial. And it's something that isn't, I think, always well understood. And it's probably not always fair because sometimes, again, uh, even though you're moving along those little steps and inching along, those inches are not moving fast enough, especially in countries where there is um, mass incarceration, where the numbers of individuals locked up is so immense. So the wheels of justice sometimes just don't turn as fast as you want. So does the speedy trial apply? Absolutely, the speedy trial applies. But a speedy trial that you think might be finished in 1 month is not what really a speedy trial means. A speedy trial means that he gets placed on the docket based on how many cases are before him. When is there a free time? When will his lawyer be able to meet? When will they be able to transport him? All of those things, and all of those things take time. So, speedy trial is not what you're imagining it to be. Real life law is not like your drama shows. So if anyone learns about the law through dramas, that is not where you learn them. Not where you learn them, please. They tell you a lot of weird things that just won't happen in real life. During the appeals process, he has 7 days, depending on what happens. If the appeal gets accepted and he gets bailed, then he can be out and about. If the bail process takes a little longer, then he will probably still be held in military custody until the date of his release from the military. Once that day comes closer, then they will decide where to transfer him to. Usually, it will be a civilian center, unless they're transferring him to prison, and that will happen if he does not appeal. So, if a person who's been found guilty does not appeal during their time frame, that means they have accepted a guilty verdict. And if they accept a guilty verdict, that's when they get transferred to prison. But so far, there is no reason to think that he's not going to appeal. Again, I said there is no reason to think he's not going to appeal. That doesn't mean that he won't appeal or he will appeal, just that there is no reason to believe he won't. Okay. Trial decision itself, I send you off to read a Business Mirror article article if you want to know anything about my opinions about that. I send you to Business Mirror. I think that was fairly explanatory about how I view the legal analysis of what went down. But I'm going to keep moving on towards the appeal process since this is such a large part of what we're going. So, all right. Effective arguments to overturn convictions. It's going to be very, very important to think about what are some of the arguments that you can make. You can say, and I'm going to start with this mainly because I think it's a potential that could be out there, but this doesn't necessarily mean that I'm saying this will happen or it should happen, but it is a potential. These are some of the arguments that could be made for the appeals. One, you could say that your legal counsel, meaning the person who's defending you, was ineffective. You could claim that that could be a potential argument that is made. And if that happens, then you're basically saying that my lawyer failed me, and here's the many ways that they did. And it's one of the things that a lot of times do get used in appeals in real life because there are a lot of individuals who don't have the money to hire their own lawyers or who are of unfortunate financial circumstances and they cannot afford to get themselves lawyers who are experienced and competent, and many times their lawyers do fail them. So when that happens, ineffective assistance of counsel is a very good grounds and argument. Something else that I would probably, I'm just going through and giving you some of the arguments, mainly because you guys probably haven't heard these types of arguments or you have heard of some of them. So, rules of evidence is something that is very important. Rules of evidence tells us when and how lawyers can submit corrector evidence. The corrector of a person should not be admissible. So, in SR's case, it doesn't really apply because there wasn't corrector evidence that was against him anywhere. So this wouldn't necessarily apply for him. But again, other types of evidence presentation might then apply during the pretrial phase. The evidence is that they decided to accept. Let's see. It could also be something where a defense attorney, and this actually could be done in SR's case. In fact, I think it's very potentially possible to do it in SR's case, where SR's lawyer for the appeals argues this improper shift of the burden of proof. Basically, he is arguing that the prosecution has the burden of proof to prove beyond a reasonable doubt that the individual charged with a crime is actually guilty of having committed that crime. The prosecution has that burden of proof. However, the prosecutor managed to shift the burden of proof onto the defendant by suggesting that the defendant, SR, had to prove his innocence. And I think this is a very doable argument in SR's case, because if you think about a lot of the trial processes that we've heard and some of the questioning, in fact, even some of the statements made during the closing arguments and from the verdict, there seems to be a particular shift of burden where there is a suggestion, okay, you didn't do it. Why aren't you showing me why you didn't do it? Why aren't you showing me that you're innocent? That's an improper shift of the burden of proof. I would probably use this argument myself. What else? Let's see. I might also do something regarding witnesses. I don't know what quite yet, mainly because I don't have all of the information. Something that stands out to me is that SR Stye did not have witnesses on stand. Um, so I would consider trying to bring in an argument regarding witnesses, if not from the prosecution side, because they tended to favor SR. See if there's something I could do as far as arguments, as to not being able to bring in their own witnesses. And yes, there was many factors in play there. There was the fact that witnesses were in a different country and there was coronavirus, etc., etc. However, not having had those witnesses did have an effect on the trial. I believe they did. Having witnesses stand in court on his side could have changed the ballots even further. So I think I would do something with witnesses. There is also something else that I might try to argue, and again, it would depend on, how much of the information that we have in public is reliable and how much of it is missing. But something that I think that I could argue, and would be very appropriate to argue in this case, would be the fact that um, there was a lack of probable cause. I could try that. I could try the fact that to indict SR, that probable cause and that burden of proof was not met, because all the evidence that was used at that time was insufficient, because the witnesses said that they only pointed to SR not because they saw him, they wanted to say he did it, but because they felt pressure, etc., etc. So I could use some of those arguments to build a case that there seemed to have been lack of probable cause to have accepted an indictment in the first place. And if an indictment couldn't have been accepted, then how could the rest of the trial have proceeded? So I probably would try something along those lines as well. As you can see, there's so many avenues of argument, and the more information a lawyer has in front of them, the more they can talk about and try to think of different types of arguments. Um, on the same line as the fact that there seemed to be a lack to indict, I would also mention that there was definitely a lack of sufficient evidence for a conviction. That would be probably one of the biggest arguments that I would make in this entire appeal: a lack of sufficient evidence to convict. I haven't seen it presented to us at this point. And hey, maybe there's some evidence that we don't know that hasn't been made public. But if those evidence aren't substantial, if those evidence has not proved beyond a reasonable doubt, then it's not sufficient. If there is a small reasonable doubt, even if it's a small doubt, but it's a reasonable doubt, it can be reasonably leading someone to think, huh, is it possible that he might actually not have done it? Huh, is it possible that he's not liable? Huh, is it possible he's innocent? If there is even a small reasonable doubt, then it is insufficient. It is a lack of sufficient evidence. I would definitely go that route for this particular argument. Um, Faulty witness statements. I might even argue about incorrectly um, attaching his case to a co-defendants, even though they're tried separately. If he's still been made a co-defendant, I might try to bring that in if possible. It would depend on the rest of the files, which I don't have, but that's a potential. Um, I would also add in my argument for the appeal that the fact that the defendant is innocent, that would probably be something that no matter what I would want to put in: defendant's innocence. Um, this person is innocent. Um, Something at this point that should be mentioned is that in the United States of America, during an appeal, you cannot submit any new evidence. So, in the United States of America, during an appeal, when you're submitting it to be reviewed, you cannot produce new evidence. In South Korea, during an appeal, you can produce new evidence for review. So, as I make my argument for the defendant being innocent, I would try to see if I could produce evidence to support those claims, not just ones that already exist. I would try to see if there's something further. Um, and of course, I don't have his case file in front of me, so I don't know where to pursue further evidence from. But if I have a case file in front of me, and if I have done all that review that I said I would do at the very beginning, then I have already marked avenues that I might pursue to see if I can find further evidence uh, to submit. And in South Korea, I can. In United States, it's a no-no. Um, So I'm not just going to keep talking anymore because the truth of the matter is, if you leave me to quietly sit here and think, I could probably think of at least 5, 10 more arguments, and that's just me sitting here without his rail file. If you leave me to sit here and quietly think up for other arguments that can be used during the appeal, there's so many that I could think of, and they're all based in the system. They're all based in that system, um, including, as I said, the facts, the interpretation of law, the Constitution, court procedure. There's just so much. I could probably come up with tons more, which is going to be boring for you. So I won't continue on that path and take up any more of your time. But I will read comments. I will read comments, and I will mention the fact that my batteries are slowly dying. So, um, in about 20 minutes or so, we will wrap this up. It's also been an hour and 30 minutes. So, I think 20 more minutes would be very reasonable time for me to call it done for today. Okay. All right. So I think hopefully my telling you some of the um, arguments that can be made during the appeal kind of gives you an idea of just how robust the possibilities are, and depending on the prosecution, if they're going to. Okay, let me go back one more step. Let me go back one more step because you guys probably don't know this. So let's assume that 7 days, the defense files an appeal. What happens next? Defense files an once something like that takes place, then it gets submitted in paper document. While the court of second instance is reviewing this, the government has a chance to also respond to that. Who do I mean by the government? The people. The people is represented by the prosecutors, but in the United States of America and in South Korea, the people are represented by prosecution. So prosecution will have a chance to respond to any appeal document that says, hey, I want to appeal, I don't agree. So prosecution responds. After prosecution responds, the defense responds. So defense files, court starts reviewing, prosecution responds, defendant responds to the prosecution's response, counter response. Um, Hopefully that made sense in that order. So, okay, 7 days. Defendants send in their appeal, court begins reviewing, prosecution responds to that appeal, the defense re-responds to that appeal from whatever the prosecution says, um, and then the review board makes their decision. So it sounds a little complicated, and it is, but that's the way it goes. Uh, In an appeal, the burden of proof is on the person who brings the appeal, the defendant. Yes. Big yes, that's how a lot of us saw this trial process. They shifted the burden of proof and they presume he was part of the crime. So as I mentioned, there's just so many avenues of arguments there, and I don't even have his case file. All I have is reports that come from the court cases, from, you know, reports. That's all I have. So based on the actual filed transcripts, I'm going to imagine there is numerous arguments that any competent lawyer would be able to come up with. um Michelle Ray over here mentioned something about witnesses, foreign witnesses in camera. So as we were talking about, one of the arguments I might have made was how not having the witness has affected his case. This could be something that we could have said. We could have said that why were accommodations not made available, and that should have been made available. Of course, it would also greatly depend on if the defense had asked for accommodations. But again, definitely an avenue that could be pursued and should be pursued. Again, I would do a lot of these things if it was me out there. Um, Someone says that they heard that the Japanese investors wanted to testify, but they didn't let them call them as witnesses. I haven't heard it. If you've heard it, I'm assuming you've heard it on social media. So I don't use social media to base my legal opinions and analysis on, because social media tells you a lot of weird things, uh, such as to inject yourself with bleach in order to stop the coronavirus. So um, do not use social media to gain your personal information, whether on health science or on law. Okay, time moves fast. I find it interesting essays, but your poor throat. Um, okay, so I'm going to actually switch gears back to this computer on this side because there's still questions left over here. You guys can obviously keep typing more in here, but let me switch gears to make sure if there are some things that I haven't covered that won't get covered unless I directly respond to them immediately. Um, and water break at the same time too. Okay, most of them are still very related to the appeals process, so I'm just going to continue down my appeals process. It's a long, you guys. Appeals process. What I have to tell you is very long. All right. So I've told you about the arguments. Now let's talk about what would I say? The requirements. You filing that notice of appeal in the 7 days that I mentioned. You obtain your trial receipt. You want to make sure you have everything, every sentence said, every I's, every T's crossed. You want the entire thing. It's probably gonna be like this. It's gonna be like a book. It's going to be a book. It might be several books, in fact, given the fact that we're talking about several years and several hearings. So, yes, maybe more than one book at this point. So, you're going to obtain all of that, and then you're going to submit what we call an opening brief. What is this brief? This brief is exactly as it sounds. It's a briefing. You decide to brief the court on the case at hand. This takes place after the 7 days. So, what takes place in the 7 days is filing that official report. I disagree with you. I'm appealing. The briefing takes place after 7 days. This is when you take a lot more time to do a lot more detailed work. This is where you describe what happened at the trial, why the decision was wrong, why the court should reverse the verdict of guilty, or why they should reduce the sentencing, why the sentence is not uniform to what it should be, or perhaps it should not be sentencing at all and it should be suspended. This is where a lot of those arguments I was talking about earlier gets taken in detailed briefing information. So, remember how I said that the defense submits information, the prosecution will respond to that, and then again, the defense responds to that. So that's going to take some time. All of that takes a little bit of time. While all of that takes place, the court reviews, there's one other thing that can happen for the appeals to decide if to accept or not to accept. There is the ability to also prepare for in-person arguments, meaning the defense attorney and the prosecution stand in front of the appellate and ask the court of second instance, hey, I want to appeal. And other people say, no, you should not grant them the appeal. So there will be oral arguments that have the possibility to happen. Why is this important? It's important for one reason. Once this moves on to an appellate jurisdiction, it will be heard by a panel of 3 judges. Once this moves to the appellate jurisdiction, you don't have just one individual considering and reviewing the facts. You have 3 individuals. So, being able to present your argument, and remember how I said there is also a component of having pathos, of emotion, that is so important in someone who does appeals. So I'm going to say that this portion of the process is going to be extremely crucial, and it has to be done well. It has to be done extremely well. It has to be prepared well. And then after that, there's the decision. The decision is what the appeals court decides. They're going to review everything, hear everything, and they're going to deliberate. They're going to consider, is there a reason to think that the court's decision could have been wrong? Now, they're not deciding that the court's decision was wrong. There's a difference between that. Deciding a court's decision was wrong means they're overruling the old decision. They can do that in some cases, but in most cases, what they're deciding on is it could have been wrong. There's a huge possibility, based on what I'm seeing here, that it could have been a wrong decision, and that perhaps it should be reversed, or it needs to be examined to see if it should be reversed. If that happens, then the court agrees to move forward with the case. If the court believes there are legal reasons to doubt the verdict, to doubt the result. So at that point, if it gets accepted to start a new hearing, that is a very big possibility. There is also the possibility, as I said, if someone doesn't want to change all the verdicts, if they want to perhaps look at sentencing, there is also the process of just changing the sentencing. Say instead of 3 years, you believe it's something that's worth 1 year and 4 months, and you believe that based on all the evidence and based on mitigating circumstances, crimes have aggregating factors and mitigating factors. So based on mitigating factors, that this 1 year and 4 months should actually be suspended. And then you argue down the sentence. So there are end results possible where he gets a reversal of his sentencing, where a new trial takes place, or where his sentencing changes. The sentencing can be changed to a lower sentence, or the sentencing can be changed to a suspended sentence. And yes, his sentence can be suspended, despite some weird rumors that have been going around on social media. There is no legal reason why his sentence cannot be suspended, except for the fact that the court might not decide to. So okay, so I think I have covered most of the appeals process. I think I've mentioned from top to bottom what I would do if I were in the appeals. So I think I'm going back through all of these questions to see if I've actually answered every step of it. Okay, here's a question. What can the judge do at the appeals with the case? Okay, so the question is asking, what can the judge do? I think they mean the appeal judge with the case. The new court can decide to keep the conviction the way it is. It's called affirming. It can, again, decide to remand the case, meaning you need more proceedings. It can possibly reverse a conviction. It doesn't always do that, but it can. It can also change sentencing from lowering it to suspending it. Hopefully that really answered that exactly the way you wanted it. Um, all right. Trying to see if there is any other questions that was sent to me either in DM form or anywhere else. I tend to collect them all. Actually, let me correct myself. I don't do the collecting. VLM's Mr. R does all the collecting. He spends a lot of his precious time putting all of these questions together from all the different platforms in which people can ask questions. So let me correct myself there. I do not collect them. This is Mr. R's hard work, not mine. All right. I think I have managed to cover the appeals process pretty fully. So I'm going to go um, look at your set of comments at this point. And it also mentioned to you that my battery is now almost gone. So I'm going to read your comments and then I'm going to conclude. A lot of internal questions about proofs, etc. As I've mentioned, that there has been a lack of dotted lines connecting evidence. There has been none that have been shown to us. So, from what we know and what we have seen, there is a very, very big lack of evidence. But that's again from what we know and what we've seen. Okay, so I'm not sure if this is a question to me or not. Not super important, but when initially filed, is there any hint of the why on what might be elaborated in the big debrief? Are you I'm going to have you clarify that question for me. So please clarify that. Is that question to me? And when you say when initially filed, do you mean when an appeal is initially filed? Is there a hint of why that appeal is filed? As in, yes, the defense attorney has to mention why they are filing an appeal. A defense attorney cannot just file an appeal because they don't like their trial judge, or they think that their trial judge is biased. It cannot just be a thought up here that I got the short end of the stick. I don't like this judge. This judge is biased against me, or this judge is biased against my client. It cannot be just a simple thought. If there is a thought of any kind of bias or any kind of legal problems or anything along those lines, that has to be down in writing and that has to be shown. So yes, if that's what you're talking about, yes, this is not something you do arbitrarily. This is something that has to be reviewed, because if they don't think you make any sense, it gets thrown out the door. Again, why there are lawyers who have specialty areas in appeal, and some of the best appeal lawyers understand how to go about the process a lot better than a common defense lawyer can. Just for your information. This is someone discussing the fact that certain somebody else had appealed and their process was done faster. Of course, it's possible to get it done sooner as well. When I'm trying to tell you is the justice can take time, but that doesn't necessarily mean I'm giving you a time frame. The time frame depends on the court's docket. It depends on the court's docket. How many cases before you, how many cases after you, what is your lawyer's schedule, how many clients does your lawyer represent, how many ongoing court trials are they doing right now, which one are you in their number. all of these things. It's not just the prosecution, it's your lawyer too. Does your lawyer have 10 cases? Does your lawyer have 15? Does your lawyer only have 2 at the same time? Can you see the difference within what happens if your lawyer has 10 and 15 versus if your lawyer only has 2? There's a world of difference. So understanding that speedy process is not only dependent on one side of the court, but on all parties involved is very important. How busy is this particular judge? How busy is the prosecutor? How many things in the docket? What about the defense? Are they free? When are they free? In the higher court, the burden of proof is higher, and if the defense appeal, that means the burden now is on the defendant's side. Okay, so let me see if I can understand this. The burden of proof in a criminal case is the highest, which is called beyond a reasonable doubt. In every criminal case, whether it's in the United States or in South Korea in this case, that is the highest level, the highest burden of proof beyond reasonable doubt. So the proof has not changed. It has always been the same. Court of second instance is a court that is authorized, empowered to judge the ruling of the court below them. An easy explanation would be something like this. The court of first instance is your teachers or your professors. Something goes wrong in class and you think that your teacher did something wrong, your professor did something wrong, you go to your department head. The department head has the same rules that they follow as your teachers do. That hasn't changed. What has changed is your department head has the authority to investigate and review what happened by your professors or your teachers. One level higher, maybe you don't think your department head took your complaint seriously. Okay, let's take it to my dean. Or if you're in school still, high school, secondary school, your principal. So you can take it to your dean if you're in a level of higher education, or you can take it to your principal. I feel that the individuals did not properly consider these particular rules that apply in our school. These are my arguments why this should have happened. And these are my arguments why they did this. So the rule itself doesn't change. The rule is written into code and law. What changes is who has the authority to review who and make a judgment on if those people were correct or incorrect. So the court of second instance can review and say the court of first instance was incorrect. The court made a bad decision. They were wrong for these reasons. The court made a good decision. I agree with them for these reasons. The court had a difficult job to do, and they used their discretion to make a particular decision, and we will stand by that decision because it's a matter of discretion that is constitutionally allowed to them. They can say that. So it is the power to review another level of court. So the burden of proof is still the same. Okay, next. If just the defense appeal, that means the burden is now on the defendant's side. In the appeals process, the burden is on the defense to show there is a reason to believe that the court has done something incorrectly. So if I claim that my teacher has messed up, I should have had an A, but my teacher gave me an F, how could my teacher do that? Then it's my job to show why did I deserve an A instead of an F. Similarly, if the defendant says the court is wrong, the defendant has to give a reason why the court is wrong. So the appeals process, it is on the defense. The burden of proof has shifted towards them. So you're correct. The appeals process, and it's this process. The appeals is not a new trial, it's an appeals process. Some people might call it a trial, but it's really not a trial. The appeals process has the burden of proof shifted towards the defense or towards whichever party brings the appeal. Because remember, in South Korea, the prosecution also has the right to bring an appeal. So whichever party brings the appeal has to show this is why I deserve an A. Why did I get an F? And my battery is just about out. I'm going to read anything else left. Is that file public though, or is it made public legally? Okay, so I think that's going to be my last answer because my thing is starting to stall. The last answer is this, that judgments are usually not 100% made public. However, it is available at all times to the defendant themselves. So if you're someone who's been accused of a crime, you're the defendant, SR is the defendant, it is available to them. It is available to their family members. South Korea allows that. It's available to anyone who can legally represent them or has a power of attorney for them. Um, it's also available to close relatives, and very interestingly, it's available to their employers. Um, but in SR's case, he doesn't have an employer. So it won't be fully made public in this case, but it will be available to particular individuals who legally qualify. So, on that, I thank you all very much for staying with me today for 2 hours and 2 minutes. And I basically used up all of my battery. I have 8% left. So, as you take off, I want to leave you with one thought. The game's not over. The ball's still in the court. That ball is in the play. We don't know where the ball is heading, but until the game is over, the game is not over. So watch for facts, watch for rules of law, watch for analysis of the law. When you do your own research and form your own opinions, try to form them not based on social media, but from reliable sources. And also, when you are judging the meaning of what you're reading, keep in mind that simply being able to read something doesn't always make you understand what it means. For instance, the 7 days process is just paperwork that everybody does. The certificate that people were worried about on Twitter is, again, everyday process that gets done in every court in America and in South Korea. You cannot withhold that because there is no way to withhold it. You do it after every single hearing, whether we're talking about someone who's got a speeding ticket, a jaywalking fine, or someone who's a murderer. It's procedure. So always keeps those things in mind. Don't jump to conclusions. SR's case is wide open. There's a lot we don't know yet. So, on that note, take care and good night. You're welcome, guys.